RC and co-lawyers provide services in the subfield of strata and subdivision. In this subfield of law, our firm provides guidance to owners corporations, residents and service providers on matters relating to owners corporation disputes. Guidance is provided through legal advice and representation in tribunal or court hearings. We also provide guidance by attending and or communicating with the relevant stakeholders in that industry. If you have any questions in relation to complex strata and subdivision matters, please do not hesitate to contact us at RC and co-lawyers.
Good morning, Strata enthusiasts. Welcome to Live Breakfast with Managers Strata Law Week. I am Ria, here to present the host of this morning's live stream, Rochelle Castro, Strata lawyer.
Good morning. It's a beautiful, warm weather in Melbourne. I'm Rochelle Castro here at Breakfast with Managers, Strata Law Week. Yesterday, we briefly discussed on the changes to the Owners Corporations Act, focusing on proxies, general meetings, interim resolutions that could be passed, and committees. Today, for the next 15 minutes, I will be exploring with you, looking into the changes that directly impact the managers. So let's get started. Slide us up. So what we will be touching on are Part 8, Part 11, and Part 6 of the Owners Corporations Act. We'll focus on the rules of the Owners Corporation, applications to VCAT, and managers, which is a large part of today's presentation. Next slide. So Section 138B in the amended Owners Corporations Act focuses on the power to make rules about external alterations and other works that affects lot owners. In this piece of provision, it gives the Owners Corporation the power to make rules that relates to external alterations and other works that would impact lot owners. But the OC would not be empowered to make rules that will unreasonably prohibit any installation of sustainability items on the exterior of a lot, such as solar panels. So there's a limitation to the powers given to the OC when it comes to making rules. Next slide. Section 169I is a provision that allows lot owners to apply to VCAT to commence, prosecute, defend, or discontinue any proceedings on behalf of the Owners Corporation. Now, Section 163, subsection 1A will remain, which allows that provision, which I've just mentioned, which is highlighted there in blue. The addition of Section 169I expands the provision 163, subsection 1A, so that the lot owners will be allowed to ask or seek orders from VCAT, authorizing lot owners to prosecute, defend, commence, discontinue a particular proceeding on behalf of the OC. In this type of entitlement, applicants or lot owners who make the application will have the burden of proving why the orders should be made, where the OC has not passed a special resolution, or where the special resolution has failed if it was attempted, and an ordinary resolution would not have been passed. On the other hand, those who are responding to such application will have the burden of proving why the orders should not be made, where the special resolution has failed and an ordinary resolution would have passed. Next slide. Let's get down to how it impacts now managers. Section 119, appointment and removal of managers. And this requires Tier 1. We've touched on Tier 1 in day 1 of this live stream. Tier 1 OCs must appoint a manager unless it is authorized by a special resolution to opt out of that requirement. So there is a special resolution requirement if they don't want a professional manager. But this can be reversed by subsequent ordinary resolution. Tiers 2, 3, 4, or 5 OCs has the option of appointing a professional strata manager. The term of appointment must not exceed 3 years. So contracts beyond that would be deemed void. Next slide. Section 119A focuses on the contract of appointment. In this provision, the following are considered void terms in contracts of appointment. If there is there's a condition of revocation of the contract, and the OC pass a resolution other than an ordinary resolution, or the term requires that a general meeting must be convened, a provision is void in the contract if it allows the manager to renew the contract at the manager's option. A void provision in a contract is a requirement that a Tier 1 or Tier 2 OC give 3 months or more notice on its intention to revoke the contract. On the other hand, if there's a requirement that the Tier 3, 4, or 5 OC give 1 month or more notice of its intention to revoke the contract, that is also considered a void term. A void term would cause the contract to automatically roll over if the OC fails to give notice of its intention not to renew the contract. Another void term is that there's a restriction in the ability of the OC to refuse consent to an assignment of that contract, other than a requirement that such consent must not be withheld unreasonably. So have a look at these managers. To our other viewers who are not managers, kindly take note of these provisions that are now expressed to be deemed void in contracts of appointment when it comes to hiring professional strata managers. Next slide. Section 122, subsection 1A focuses on the duties of the manager. Some of these are not surprising. They've been in the old act, but some of them have been expanded. So there's an imposition on managers of further obligations to carry out their functions as manager, which includes taking reasonable steps to make sure that any goods or services procured for the OC, meaning other service providers procured on behalf of the OC by the manager, are competitively priced and on competitive terms. There must not be any exertion on pressure on any member to influence the outcome of a vote. Before entering a contract, the manager must disclose any benefit that they will receive by reason of the OC it is managing and to entering into the contract. Next slide. Section 122, subsection 2, further provisions on the duties of the manager. There's now an interposition on an additional obligation when it comes to the OC's accounts, which includes holding the money separately for each owner's corporation on a plan of subdivision. So that includes a separate account for OC1, separate account for OC2, so on and so forth, on trust. Unless, of course, the owners' corporations, the multiple owners' corporations, agreed that they be held in the same account. But there has to be an agreement from the owners' corporations. And that would include interest earned. So there would have to be an agreement between owners' corporations on how the interest would have to be dealt with if the account would be joined. Next slide. Section 122A focuses on managers disclosing beneficial relationship with a supplier. This provision requires the manager to disclose if it has any beneficial relationship, and there is a definition in the Owners Corporations Act, and that could mean not necessarily financial benefit, but even transactional or a commercial benefit that they receive from any supplier before entering into a contract for the provision of the goods and services. And the key word there is before entering into the contract. So there has to be a disclosure made to the owners corporation. Next slide. Section 122B. Manager must disclose commission, payment, or other benefit. This is an extension of Section 122A. There's a requirement now that the manager disclose if it will receive a benefit before entering into any contract for the provision of the goods and services. Next slide. Professional indemnity insurance of the manager is provided in Section 185A. There's a requirement to notify the building licensing authority by the manager if they cease to be covered by any professional indemnity insurance. Next slide. Now, take note of these transitional provisions. These transitional provisions mean that the amendments to the Owners Corporations Act has given time to be allowed for any changes or adjustments that need to be made by the Owners Corporation. And there is an appreciation when the government was considering the changes to these acts in respect of the practicality and impact on practical operations of the owners corporation. Thus, there have been transitional provisions, and they are the following. For Tier 1 owners corporations, so this is owners corporations that are 101 plus occupiable lots. They have until 1 December 2022 to improve and adopt a maintenance plan. So to those of you who are developments out there for managers, if you have developments that you are managing that are under Tier 1 OC, there's 1 year for you to approve and adopt a maintenance plan. For owners corporations Tier 2, which is owners corporations that have 50 to 100 occupiable lots, they have until 1 December 2023 to approve and adopt a maintenance plan. for contracts of appointment that are deemed voided by the new act applies to those terms from 1 December 2021, even if the contract is pre-existing. So the renewal of contracts from 1 December 2021 would be impacted by the provisions in respect of the voided terms as recognized by the amendments to the Owners Corporations Act. And finally, the new financial reporting obligations apply from the commencement of the OC's financial year after 1 December 2021. So that means that general meetings, particularly annual general meetings that are held after 1 December 2021 would be impacted by these provisions that we are covering in respect of Owners Corporations Act and Owners Corporations Regulations. Next slide. That sums up the provisions that relate to making rules under the Owners Corporations Act amendments, the provisions in respect of managers, the impact on their operation, and the contracts of appointment. We're getting down tomorrow to the last day to cover what's left with the Owners Corporations Act. I'm also looking forward to exploring with you what are the changes to the Owners Corporations regulations. I'll see you tomorrow in this live stream, Breakfast with Managers, Strata Law Week. Rochelle Castro, Strata Lawyer. Have a good day.